Good afternoon. Regarding the 2025 Sharia Special Bar examinations, the grades of the examinees are now available at the Barista app. The list of passers and the top 10 will be posted on the Supreme Court website. Next, the Supreme Court has ruled that the House impeachment complaint versus VP Sara Duterte is barred by the 1 year rule and that due process or fairness applies during all stages of the impeachment process. I quote, "Our fundamental law is clear. The end does not justify the means." Another quote, "There is a right way to do the right things at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment." End of quote. In a unanimous decision today, July 25, 2025, the Supreme Court en banc declared the articles of impeachment against Vice President Sara Duterte unconstitutional, noting that it is barred by the 1 year rule under Article 11, Section 3, Paragraph 5 of the Constitution, and that it violates the right to due process enshrined in the Bill of Rights. Therefore, the Senate could not acquire jurisdiction over the impeachment proceedings. However, the court said it is not absolving Vice President Duterte from any of the charges against her. But any subsequent impeachment complaint may only be filed starting February 6, 2026. The case stemmed from 4 impeachment complaints against Vice President Duterte. The first 3 were filed before the House by private individuals and different groups on December 2, 4, and 19 in 2024. A fourth complaint was lodged by a resolution approved by more than 1/3 of the House members of the 19th Congress on February 5, 2025, which was transmitted as the Articles of Impeachment to the Senate on the same day. This was followed by 2 petitions filed before the Supreme Court challenging its constitutionality. The Supreme Court decision, written by Senior Associate Justice Marvic MVF Leonen, ruled that all legal issues involving impeachment proceedings are subject to judicial review, considering the nature of the offices and the institutions that are subject to impeachment, its effect on the independence of constitutional departments and organs, and its nature as a constitutional process. The impeachment process is primarily a legal and constitutional procedure, but with political characteristics. It may be sui generis, but it is not a purely political proceeding. This means that the Bill of Rights, especially the Due Process Clause and the right to speedy disposition of cases, applies to the entire impeachment process, it said. Although the court does not determine whether an impeachable officer may be removed or disqualified from political office, it emphasized that it has the duty to construe the process mandated in the Constitution. In declaring that the articles of impeachment were barred by the 1 year rule, the decision differentiated the first 3 complaints from the fourth complaint. The first 3, it said, were filed under Article 11, Section 3, Paragraph 2 of the Constitution, which allows any citizen to file a verified complaint with an endorsement by any House member. The fourth one was through Article 11, Section 3, Paragraph 4 of the Constitution, through a verified complaint or resolution filed by at least 1/3 of the House members. The court took note that the House and the 19th Congress did not act on the first 3 endorsed complaints, which were considered terminated or dismissed upon adjournment of the House. The 3 impeachment complaints were archived and therefore deemed terminated or dismissed on February 5, 2025. Therefore, no new impeachment complaint, if any, may be commenced earlier than February 6, 2026, the Supreme Court held. Under Article 11, Section 3, Paragraph 5 of the Constitution, no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. According to the decision, the 1-year bar is reckoned from the time an impeachment complaint is dismissed or is no longer viable. A key issue in the petitions is whether the House complied with the 10-session-day requirement under the Constitution for including a verified impeachment complaint in the order of business of the House. The court ruled that the House was able to comply with the requirement by putting the 3 endorsed impeachment complaints in the order of business of the House of Representatives, since a session day is not equivalent to a calendar day. It is a period that starts from a call to order until the session is adjourned, regardless of the passage of time. However, the court reminded the House that Article 11, Section 3, Paragraph 2 of the Constitution clearly requires that a verified impeachment complaint be immediately put in the order of business within 10 session days from its endorsement. The Constitution does not grant either the Secretary General or the Speaker of the House any discretion to determine when this period commences. Consequently, the House of Representatives is not granted any discretion except to refer these matters to the proper committee within 3 session days. However, the House may opt to consolidate all impeachment complaints properly commenced and endorsed within these periods. The court also determined that due process applies to the impeachment process. It laid down the following due process requirements in impeachment proceedings. First, the articles of impeachment or resolution must include evidence when shared with the House members, especially those who are considering its endorsement. Second, the evidence should be sufficient to prove the charges in the articles of impeachment. Third, the articles of impeachment and the supporting evidence should be available to all members of the House of Representatives, not only to those who are being considered to endorse. Fourth, the respondent in the impeachment complaint should have been given a chance to be heard on the articles of impeachment and the supporting evidence to prove the charges prior to its transmittal to the Senate, despite the number of endorsements from House members. The House of Representatives must be given reasonable time to reach their independent decision of whether they will endorse an impeachment complaint. The court, however, has the power to review whether this period is sufficient, but petitioner, who invokes the court's power to review, should prove that officials failed to perform their duties properly. Sixth, the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 2, or a betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the act must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. And seventh, to ensure that respondent in the impeachment complaint is heard under the requirements of due process in the procedure under Article 11, Section 3, Paragraph 4, the House of Representatives is required to A. Provide a copy of the articles of impeachment and its accompanying evidence to the respondent to give him or her an opportunity to respond within a reasonable period to be determined by the House rules. The Constitution only requires an opportunity to be heard. It is up to the respondent to waive this fundamental right and opt to present his or her evidence at the Senate trial. And B. Make the articles of impeachment with its accompanying evidence and the comment of the respondent available to all members of the House of Representatives. It is the House, not 1/3 of the House, that has the sole prerogative to initiate impeachment complaints. Thus, there must be some modicum of deliberations so that each member representing their constituents can be heard and thus convince others of their position. The transmittal will only take place upon the qualified vote of 1/3 of the House. We quote from the final note of the unanimous decision. It is not our duty to favor any political result. Ours is to ensure that politics are framed within the rule of just law. We cannot concede the sobriety of fairness inherent in due process of law to the passions of a political moment. Our fundamental law is clear. The end does not justify the means. We understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those at our society's margins, or those who may have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, has obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. We will not allow that to happen again. We will not hesitate to declare what is legal, just, and right for our people. There is a right way to do the right thing at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment. End of quote. The Supreme Court's ruling is immediately executory. It shall be deemed served on the petitioners and released upon publication in the Supreme Court website and receipt of the parties of their digital copy in accordance with the guidelines on the transition to electronic filing in the Supreme Court. We urge everyone to read the full text of the decision and the concurring opinions. Thank you very much.
Hi, Attorney. Ay,
Adrian.
mauna na ako.
Please
Adrian
state.
Ayalin po,
Hi,
ABS-CBN.
Adrian.
So, sa madaling sabi, wala pong magaganap na impeachment trial ngayon. Hindi pwedeng mag-hold ng impeachment trial ang Senado.
Well, the court said that the House complaint versus the VP is unconstitutional and null and void, and therefore the Senate did not acquire jurisdiction to convene as an impeachment court.
Hanggang until February 6, 2026 na hindi pwede.
The
Ganun po ba yun?
February 6, 2026, that's the date until when another complaint can be filed
Okay.
or initiated.
Okay. And wala na pong pwedeng magawa ang House of Representatives, as you said, immediately executory.
It's immediately executory, but they always have the option to file a motion for reconsideration.
Thank you, Attorney.
Attorney Ben Pulta po sa Philippine News
Hi,
Agency. To clarify lang, it was a unanimous decision. There was no division among the justices on how they
It
ruled.
is a unanimous decision, although there were two justices who did not vote. So that's Justice Benjamin Caguioa, he inhibited, and there's Justice Maria Filomena Singh, who was on leave.
Hi ma'am, Salima
Hi,
Rafran of
Salima.
GMA. Ma'am, para po mas maintindihan ng publiko, ano po yung naging dahilan ng Korte Suprema kung bakit nga po naging null and void ito nga pong articles of impeachment at hindi po dapat matuloy ito nga pong impeachment trial laban kay Vice President Sara Duterte?
Well, number one, it said that the articles of impeachment, which was the fourth complaint, violated the 1-year period ban because there were 3 complaints that came ahead of it. And although Congress was able to include it in the order of business, it did not refer it to the proper committee within the 3 days because they had to adjourn. So the Supreme Court said that they archived it, and as a result, it was terminated, therefore deemed dismissed. So the 1-year ban will start or count from the time it was dismissed. So the fourth complaint could not have validly been transmitted to the Senate.
Tapos ma'am, meron din pong sinabi yung Korte tungkol po dun sa hindi nito inaabsuelto.
Yes.
Tama. Pwede pong pakiulit yun and pakipaliwanag yung parte pong yan.
The court said it is not absolving Vice President Duterte from any of the charges against her. So that means, again, hindi siya absolved from any of the charges. But any complaint for impeachment against her can only be filed by Feb 6, 2026 onwards. Pwede pa rin.
Hi,
Yes.
Attorney. Mikael Flores of Reuters.
Hi.
Attorney, just to clarify, so essentially the decision acts on a procedural flaw on the part of the House of Representatives in initiating the complaint, and it does not really act on the merits or the grounds that were cited in the articles of impeachment, because he also said that uh, the the decision does not absolve the vice president of the charges that are lodged against her.
Yes, so the decision does not delve into the merits of the impeachment complaints against the VP, but rather it just said that the impeachment complaint that was transmitted to the Senate was void for being contrary to the 1 year ban, and that it violated the due process rights of the VP.
And in terms of way forward, when, for example, the House of Representatives invoke their independence as a co-equal and independent branch of government, how is the court planning to weigh on a possible, constitutional crisis should they defy this order of the court and invoke their independence as a co-equal branch of government?
Well, right now we cannot answer a hypothetical question such as that, but I am confident that the House and the Senate will respect the decision of the Supreme Court.
Thank you.
Pagka ganun ba, ma'am, there was a grave abuse of discretion on the part of the Congress, which is a co-equal branch of the Supreme Court of the Judicial branch.
Yes, so under the 1987 Constitution, the Supreme Court was granted the authority to determine whether there is grave abuse of discretion on any part of the government, including co-equal branches. All right. Thank you very much, everyone.